I did apologize to the president. President was offended by the act.
All right, elbows up. Elbows up.
Gang, what's up? Aaron here, Canadian Looney. It's really hard to fake relevance. It's harder to try to fake relating to people. We're going to watch two of the worst people attempt it. We've got hack CBC fake reporter David Cochrane here with our Attorney General Sean Fraser, a bum from Nova Scotia here. We're not proud of that. We're just not going to try to hide it either. Sean Fraser is a bum, and they're going to try to take away more of our rights, saying they're protecting us. What are you going to do? Let's take a peek at what these bums are going to try to sell us tonight. Oh God, it's only Tuesday.
Oh, yeah.
Well, here in Ottawa, the federal government is proposing a major overhaul of parts of the criminal code. It's called the Protecting Victims Act, and it would make murders driven by hate automatically first degree, whether they were planned or not. If the victim is a woman, the law would define that crime as femicide. The bill also creates a new criminal offense for coercive control against a partner. It cracks down on digital violence, including AI deepfakes. And finally, it toughens penalties for sexual crimes, including child exploitation, both online and at home. Joining us now is the Minister of Justice, Sean Fraser. Minister Fraser, thanks for coming in the middle of a breaking news storm. Do you have any thoughts on the departure of Kirsten Hillman? It seems voluntary and collegial. What are your thoughts there?
Look, I just sent the ambassador a note to say thank you and congratulations. She has served in an exemplary fashion. I had the opportunity to work with her on a few occasions when we were negotiating the revisions of the Safe Third Country Agreement to close Roxham Road. More recently in our engagements with Attorney General Bondi when it comes to dealing with the fentanyl crisis. She is a consummate professional, extremely smart, well-briefed, able to share information, leverage relationships. We're going to miss her terribly, and it's going to be a very tough hole to fill.
Okay, you have been busy on the legislative agenda. This, I think, today is your third piece of legislation.
That's right.
This sitting of Parliament. Before we get to the changes today, I need to ask you about C9. This is the hate crime legislation, for lack of a better term. And I know there's been some issues with that in terms of getting it through because of the lack of a clear partner in Parliament. You've cut a deal with the Bloc Québécois to accept an amendment to remove the religious exemption for hate speech. There's some suggestion that this got tied up because the Prime Minister's office wasn't fully on board, but now it appears to be there. What is the status of this? Is the Prime Minister okay with this? Will the Liberals support this and embrace this amendment? Will this exemption go away in the law?
So, a lot to unpack there.
Yes, I know. I'm sorry.
To start out, let's focus on what this law is actually about. It's about combating hate in Canada and making sure we're addressing the rise in hate crimes that have been committed against Canadians from different minority communities, including from different communities of faith.
Right.
From inception, the motivation was around the intimidation and obstruction of people outside religious institutions, preventing them from taking part in their community. The process that's unfolded over the last number of weeks, frankly, is typical for a minority parliament. We have been responsible to put forward the starting point by introducing legislation. I've had many conversations with my Conservative critics, with my Bloc critics, with my NDP critic, with Elizabeth May, with my own caucus colleagues, to understand how we can strengthen this bill. I've even entertained in public at my committee appearance, giving testimony on this bill, the very possibility of this specific amendment around the religious exemption. If committee members actually decide to embrace that change, you've got to remember that once a bill goes to committee, it's the committee that's in charge, particularly in a minority context, not the minister or the prime minister. I've had significant engagement with my Bloc critic, with other members of the committee, also with the Prime Minister's office to keep people informed as to where we were along the way. My job was to find a path forward to allow us to make good on the campaign commitment to address hate crimes in this country. As a result of the discussions we've had, it appears that seems likely. The committees, I understand, meeting right now to discuss this and other potential amendments, and I'll look forward to seeing how they treat the various proposals that are coming through that process.
So essentially it's give the Bloc this amendment, or you might have to pull the bill, because the Conservatives are not against this, and this seems to be where the compromise exists right now for you to get the parliamentary majority you need.
Certainly, but let's just actually talk about the substance of what's being proposed, because there's a lot of misinformation that is being shared around there suggesting this is the criminalization of faith, which I don't think any parliamentarian would stand for.
But there would be concerns. Like, there are certain faiths, like I was raised Catholic, right? People, adherence to that, strict adherence, think homosexuality is a sin, gay marriage shouldn't be allowed, same-sex adoption shouldn't be allowed, and might have concerns that if preaching that or advocating that they could be targeted for a crime. The religious exemption would protect them from that, but you argue the threshold's much higher than something that way.
Certainly, the threshold is much higher to willfully promote hate against an identifiable group of people. There's a difference between saying you have a point of view or reading scripture about same-sex marriage and actually promoting hate, vilifying, or inciting violence against a particular group. Moreover, the protections that this individual provision could have potentially afforded a person would likely be protected by the Charter or the existing public interest exemption. From my point of view, we should recognize that religions in this country promote messages of love, of peace, of inclusion, and I think it's a perversion of what the world's major religions stand for, to have people suggest that somehow reading scripture or holy text from a religion of your choice would somehow constitute willfully promoting hate. I grew up in a Catholic household too, read scripture on Sundays. This is not what religion is about, and I have faith that we're going to be able to move forward with the protections, including the ones that were designed specifically to protect religious communities in this country.
Okay, the legislation you brought in today, it is a sweeping effort to deal with some very serious crimes to very vulnerable people, in particular, sexual offenses against minors, exploitation, these sorts of things. You're restoring mandatory minimums that have been overturned by the courts. Now, I'm not advocating that you shouldn't have serious penalties for serious crimes, but how do you get around the court decision and the unconstitutional nature of some of these mandatory minimums that have been overturned in the past?
Certainly. So let's take a look at the recent decision that brought this to the fore for a lot of people, despite the fact there had been a dozen examples of mandatory minimums being struck down.
This is the Senville decision from Quebec, the child porn one?
Yes. That's right. A lot of people reached out to me at home. A lot of people from across the country reached out, expressing real frustration about the gap that it left, even from people who understood the narrow set of circumstances that the court used to justify its decision. But they wanted to know that people who actually abuse children, who access or distribute or produce child pornography, would face serious penalties, including a mandatory minimum of a year. This is a measure that we're putting in place today. It doesn't go against what the court has told. In fact, it reflects precisely how the court has indicated you could choose to deal with these kinds of penalties if you wish to have them. Keep in mind it was a 5-4 decision with the dissent actually accepting the existing version of the mandatory minimum. But the majority decision held that there has to be some residual discretion for those extraordinary cases where the penalty would be grossly disproportionate. The example they cited was an 18-year-old receiving without asking an intimate image of a friend's partner and keeping that on their phone. After that decision came out, I actually had a few people reach out to me who are teachers, coaches, run cadet programs, who said, this is a messy area where technology is changing how kids engage one another, and this is a real scenario. We've chosen to take the court's advice, which was supported previously by members of the Conservative caucus in the House, supported by members of the Bloc caucus in the House, who've argued that some kind of a provision that would allow recognition for that residual discretion in those unique cases where the penalty would be grossly disproportionate given the facts is an acceptable way to deal with these.
Right, okay, so because the way the court dealt with this is there was the specifics of the case itself, which was a clear case of child pornography.
Absolutely.
But in establishing whether or not a mandatory minimum was constitutional, they did a hypothetical exercise where they looked at someone who's say 18 dating someone who's 16, and they swap images, and because age of minority, there's potential issues there that would technically break the law, but the mandatory minimum would be too severe. So it's essentially what you're doing here is a baseline guidance for what the sentence would be with the discretion to go below that based on specific facts. Am I understanding this correctly? So that someone isn't unintentionally caught up in the sentencing provision?
Certainly. So the crux of the issue is that the provision as written suffers from a constitutional defect because it doesn't recognize that there are circumstances that might technically fit the definition used for the crime that in fact don't reflect an ordinary person's understanding of what sexual abuse or exploitation could be. Clearly, when you have these heinous crimes committed, you need serious penalties. But just to put a finer point on your analysis, what the court's essentially saying, or what the law will say, is the court will need to be satisfied that the penalty would be in fact grossly disproportionate before they can touch that residual discretion that we're going to preserve with this legislation. Otherwise, the mandatory minimum penalty that existed in the code, in this case of 1 year, would remain in place if the court is not satisfied that that new test could be met.
Okay. And one last quick question, because I know there's a lot there, but in particular with victims of sexual violence, you want to find some guidance for the courts here, where the Jordan decision, which said you have to have a trial within about 18 months, amplified by the Cody decision, if not, it leads to a stay. You're trying to give some guidance on what constitutes case complexity so that it doesn't go to an automatic stay, so that the victim doesn't feel that they were denied justice. How do you calibrate that, though, with the rights of an accused who would wait a long period of time? They may or may not be innocent, and there is a resource problem in provincial court systems that lead to these delays. So how do you calibrate that with the guidance you're giving?
So delays serve the interests of neither the victim nor the accused. In fact, they work against the interests of society. We have to address the underlying problem of delays. In this legislation, we're seeking to do that in a number of ways, including by reducing the timelines for certain procedures, including the adducing of evidence in sexual assault trials. But you got to ask yourself, as we clean up the procedural processes that will allow for timely decisions, are we willing to accept that someone who's been sexually assaulted may be required to live in the community of their perpetrator, not because they've been acquitted, but because the time ran out? I'm not comfortable with that consequence.
Is that a legal fix or a resources fix, though?
Well, look, it's a combination. You have to realize that even if you put the resources in place, there's going to be an intervening period until you actually solve that problem. And what we're saying is we want the court to count time differently, where time-consuming applications can certainly chew up the clock. But we also want them to explore remedies other than a stay of proceedings, to identify whether there is some other fashion where they can recognize the challenges brought on by undue delay without letting a perpetrator who's potentially committed a heinous sexual assault to go free in a community. We think we found the right balance by both addressing the procedural challenges and the remedy should time continue to drag on in some of these very troubling and serious criminal cases.
Okay. Justice Minister Sean Fraser, we appreciate you coming in, reacting to the breaking news. I know you got to go vote, so thank you for being here, sir.
Of course. Thank you.
Oh, yeah.
We'll wrap it up right there, gang. Aaron, Canadian Looney, like, share, subscribe. Not a fan of David Cochrane. Sean Fraser's got to go. We need an election. That is it. Thank you very much for watching this video. If you're interested in learning about Canadian federal politics, we show a lot of that on here. Like, share, subscribe, hit one of the buttons, click one of the other videos floating around here. We'll catch you in the next video. Thank you for watching this one. Get your Canadian federal politics right here. Everyone has an opinion about Canadian federal politics. Ciao for now.